live? Ms. Smith?
Yes, Judge.
Okay, which exhibits have you guys agreed to?
Your Honor, plaintiffs have agreed with defendants to readmit defendants exhibits 5 through 10,
Okay,
13 through 18,
okay,
20 through 22,
okay,
26, 28 through 30,
okay,
32 through 38,
okay,
75 through 76,
okay,
79,
okay.
and 90.
All right, those exhibits that are agreed to are all admitted. Let's go ahead. Any other pretrial matters we need to take care of?
Yes, Your Honor, we filed a motion to exclude certain testimony and evidence yesterday.
Okay, go ahead.
We believe, Your Honor, based on the deposition testimony that was offered by the corporate representative Allsall, as well as based on questioning and previous representations by counsel in some of the hearings we've had, that defendants are going to attempt to effectively bring in testimony and evidence related to affirmative defenses that have not been pled in this case. I'll share my screen, Your Honor, and our brief gives a good summary of what we believe the other side is going to be trying to bring in. And we'd like to get a ruling from the court, basically excluding evidence of these contentions or these points that they're going to raise. More specifically, Your Honor, during the deposition of Mr. Alam, it became apparent that Mr. Alam is now taking the position in this case that the value of the written contract, which forms the basis for the claims here in this case, had been subsequently amended or modified by the parties to reflect a new lesser value. In fact, many of the exhibits which they're trying to admit are trying to be admitted for the basis of trying to prove this amendment or this modification. And we object to that and will not be trying that by consent today. In addition, Your Honor, we believe they're going to be trying to argue, or defendants will be trying to argue, that the parties' contracts contain certain provisions that require a certain specific performance or are alternatively condition precedent to our recovering in this case. We believe the case law is clear that because defendants did not file an affirmative defense and also did not file a special denial in this case, and we have pled generally in our original petition that all conditions precedent have been met, that they cannot introduce evidence that any of this has failed. And
let's deal with these one at a time, okay?
Certainly, Your Honor.
So the first one, the argument is that there was an amendment to the contract.
Yes, Your Honor.
Is that essentially it?
Yes, and it's based on, effectively, it's the affirmative defense of, well, there are several affirmative defenses that would be implicated by this. We listed them in our briefing on, starting on page 4 of our briefing yesterday, that modification, payment, accord, satisfaction, novation, all of these are affirmative defenses. Effectively, the nature of an affirmative defense, as Your Honor knows, is not to deny any of our claims. In fact, it's not denied that there was at least a $1.3 million contract between these parties as it related to the subcontract work that my client was to perform. Instead, the argument is that that $1.3 million contract was modified to a new number of $953,000, which there's no affirmative defense pled of modification or novation to basically replace or modify that agreement. And because they have not pled that, the case law is clear. We actually cite 2 cases. I give you some long parentheticals. The ones in front of you are those cases. In Longhurst versus Clark, Houston appellate judge decided that excluding evidence of payment was appropriate because payment's affirmative defense and they did not plead payment. And also in Corpus Christi.
So again, Mr. Martinez, let's just go through these one at a time. The first one is modification of contract, and that requires that, as I understand it, that it needs to be specifically pleaded. Is that your argument?
Yes, Your Honor.
Okay. Response, Mr. Gasworth?
The issue of modification of contract and whether or not it was modified is not being pled as an affirmative defense, but the issue would come from the credibility of the witness's testimony regarding its performance and its burden to prove performance under its causes of action brought, plus the 4 corners of the document upon which the claim is based contains provisions which this evidence would be in reliance upon to argue about the terms of the contract itself. Regardless, it's a credibility issue, and I'm only arguing to the point of holding the plaintiff to its burden of proof in the credibility of those contentions and the evidence submitted before this court.
Okay,
May I respond, Your Honor?
you may.
It seems like, again, I don't know how credibility comes into play when you're talking. If he's going to put on evidence or he's going to allow his client to testify today that there was a change of the agreement from 1.3 million to $953,000, that does not go to any credibility. He is effectively putting before this court evidence of an affirmative defense he did not.
So just so it's clear, to the extent that there's the defendants are trying to argue that there's been a modification, that there's been new consideration to support modification of the contract, that has to be specifically pleaded, and that evidence is going to be excluded. I can't make any more specific ruling than that, and that will not be allowed as a defense in this case. What's your second argument?
Second argument, let me go back to the beginning, Your Honor, so I have it in front of me. The second argument deals with this idea of a specific performance. This came out again during the deposition, which is what the argument is, effectively, Your Honor, is that we failed to satisfy condition precedent to recovering money in this case. More specifically, that we did not provide, as Four Corners as the subcontracting entity, did not provide receipts, invoices, backup documentation to justify payment. Number one, that's not in the four corners of the document that forms the basis for this claim today. And number two, it is effectively an argument that we did not satisfy a condition precedent, which at this point has been waived because no special denial was made as it relates to condition precedent. And we cite case law in our papers, Your Honor, to that point.
Response?
Yes, Your Honor. This is all about the plaintiff's obligation to prove under its burden of proof, performance under the contract upon which it sues upon. Also, there are three causes of action that are brought before this court today: breach of contract, quantum merit, and unjust enrichment. All requires different levels of proof and different levels of proof of performance and the value of that performance. My argument is simply to hold the defendants, the plaintiff, to its burden of proof to prove the essential elements of its claims brought against these defendants.
Okay, give me a second.
Because I would like to point out that under either a quantum merit or an unjust enrichment theory, the burden of proof is on the plaintiff to prove the value of the goods and services brought.
All right, let's go to 93, Rule 93. Okay, so where do you, I don't see in 93, maybe I'm missing it.
No, Your Honor, I'm speaking to Rule 54.
Okay, let me go to Rule 54. Okay, all right. Pursuant to Rule 54, any argument as to the condition, the affirmative defense of condition precedent is going to be barred because it wasn't specifically pled. What's the next one?
The next one, Your Honor, is lack of consideration. Same argument. We believe they're going to contend that we did not provide consideration for this agreement or that there was a want or failure of consideration. Similarly, that is
and that's under Rule 93, correct?
Yes, Your Honor. There's that, but there's also the rule requiring you to plead affirmative defenses or they're waived, which I believe is Rule 94, Your Honor.
It's not going to be my argument today here, Your Honor. My argument today is to hold the plaintiff to its burden of proof on proving its performance under the contract that would entitle it to a breach finding and damages.
Okay. So that defense is also, if to the extent it's being made, is struck, but we'll see what the evidence is going to show. What's next?
The final one, Your Honor, is alter ego, which this court is familiar with based on the last hearing. We have
that hasn't been pled either, correct?
Yes, Your Honor, correct.
And any argument as to alter ego will be struck as well for failure to plead. Okay.
Your Honor, before you close that last point out, I would like to point out that in the plaintiff's operative pleading, and if I may share my screen and show it.
Sure.
I would point out clauses 13 and 15, which specifically state, in accordance with the verbal and written agreement, defendants made payments directly to plaintiff in 2017 and 2018 totaling $498,550. Subsequent to those payments, defendant Alam requested that the owner of the project, Theon Coe, deduct payments from future construction draws to reimburse this plaintiff for its work. Pursuant to that request from defendant Alam, the owner deducted approximately $552,289.90 to the plaintiff. In their operative pleadings, they link the actions of the owner of the project, Mr. Coe, to compensation owed and due to Four Corners. It's not an alter ego theory per se on a defense side, but it's evidence as admitted in their pleading that a separate and distinct party took monies from a separate and distinct contract to compensate this defendant, this plaintiff.
Your Honor, and if I may, this again, we don't have any quibble with talking about how the payments were made, because in fact, part of our damage analysis is giving credit for the payments that were made to the owner. The issue that we have is the fact that Mr. Gasworth wants to come in here and try to blend all of these entities together and suggest that there was some nefarious fraud that was being perpetrated, which is not sufficient. Again, there's no evidence of it, but the alter ego itself should not be pled or no evidence of the alter ego itself shouldn't be allowed because that is a defense or that is a theory of recovery that hasn't been pled in this case. We have no issue with them talking about what are in the pleadings or talking about the nature of how these payments were made or how they were processed or how offsets and adjustments were handled. In fact, that's going to be part of our case too. Because we're not coming in here asking for more money than we're owed. We're just coming in asking for the money that we're owed. So again, I think the ruling as to alter ego can still stand. And if we want to talk about how payments were handled between the owner and Four Corners, we're okay with that, Your Honor.
Okay. All right. Anything else before we start opening statements?
No, Your Honor, not from plaintiffs.
Defendants?
No, sir.
All right, let's go ahead and start with opening statements. Ms. Smith, can you time them? They each have 10 minutes.
Sure, Judge.
And give them a 2-minute, 1-minute countdown.
Okay.
All right, go ahead and proceed.
Share my screen, Your Honor.
You may.
Thank you, Your Honor. Can you see that, Your Honor?
I can.
Thank you. May it please the court, my name is Nathaniel Martinez. I'm here on behalf of the plaintiff, Four Corners Development, LLC. We're here today in cause number DC 1919159. I'm joined today, as I indicated earlier, by Joshua Minton, associate here in my office, as well as Mr. Tien Coy and Mr. Gary Lee, both of whom are here representing Four Corners Development, LLC in this case. The case is simple, Your Honor. This is a dispute over payment to a subcontractor under an undisputed agreement between the parties. The subcontractor, Four Corners Development, is a limited liability company that provided certain consultation, work, goods, and services relating to furnishings and specialty materials for a project called Highlands Village Senior Living at Mansfield. This agreement was entered into as early as 2017, and testimony and evidence will show that both sides agree that as early as late 2016, there was an understanding that Four Corners Development, my client, would be providing all of the specialty furnishings on this job. The agreement itself to provide those furnishings and the compensation that would be received by Four Corners Development LLC was later memorialized in March of 2018 with a written guarantee and an agreement by Mr. Alam, who was the president of Allsall Construction, Inc. In front of the court today, as has been pre-admitted, we have evidence that shows that Mr. Alam agreed to pay my client $1.3 million and up to $1,563,000 in connection with the work that the Four Corners was going to perform on this project. The full balance would be paid 14 days after all of the funds were released on this project. And for any amount less than $1,496,000, Mr. Alam was required to provide substantiated evidence to justify the payment shortfall. Four Corners did its job. In fact, Four Corners spent over $1 million on furnishings for the project in reliance on the written promise and guarantee by Allsall and Alam. Allsall made partial payment in connection with this agreement and admits that it did make that payment. Allsall and Alam then breached by refusing to pay the difference between what had actually been paid and credited in offsets and adjustments towards this contract price, and are now claiming, for whatever reason, that we are not entitled, Four Corners Development LLC is not entitled to the money that it was promised under the unambiguous agreement between the parties. But Allsall and Alam's position is belied by the evidence in the law. One of those pieces of evidence that you'll see today, Your Honor, is a pre-admitted exhibit, PX 32, which shows a payment record dated March 21st, 2019, wherein Mr. Alam guarantees to Mr. Coy, a representative of Four Corners Development, that he would pay at least $1,047,050.70 towards that $1,496,000 subcontract price with Four Corners. Just for the court's reference and as a courtesy to understanding the nature of this project, the project itself is called Highlands Village Senior Living at Mansfield. It's an assisted living and memory care facility. It's currently only functioning as an assisted living facility due to some issues with construction on the memory care side, but that's not the issue today before the court. The owner is Highlands Village Senior Living LLC, as this court has heard in previous hearings, and the defendant, Allsall Construction, is the general contractor on the project, and its president is Parways Alam, who's also an individual defendant in this lawsuit. Plaintiff Four Corners Development is the subcontractor that was engaged to handle all of the furnishings for the project, and under those verbal agreements that started as early as late 2016 and then were memorialized in March of 2018. We have several pieces of evidence, and you also hear live testimony today, Your Honor, regarding the agreement for furnishings between Four Corners and Allsall. First, you'll see that there's going to be testimony and there'll be documentary evidence that shows that as early as 2017, payments were being made by Allsall to Four Corners directly and pursuant to lien releases that Four Corners had signed and provided to Allsall at its request. These are the same types of lien waivers and agreements that are provided to all subcontractors on projects like this. In March of 2018, which the court already saw, you'll see the guaranteed payment agreement that was signed by Allsall, memorializing the agreements between the parties. And in addition to that, Your Honor, and although this is more evidence of the contract between the parties, there were emails after the fact that Mr. Alam had sent to Mr. Coy over at Four Corners, confirming the amount of money that would be paid and confirming and basically reiterating the promise that over $1 million, $1.3 million would at least be paid on this project and basically paid towards that subcontract price that Four Corners and Allsall agreed to. I've already shown you this, Your Honor, but I think it bears reading. In the March 19th agreement in 2018, Mr. Alam states that he will promise to pay a guaranteed sum of $1,300,000 and up to $1,563,000 to Four Corners Development LLC for consultation, work, good, and services provided in relation to Highlands Village Senior Living, which is the project at Mansfield. And in addition, he says at the very bottom of this, for any amount that's less than $1,496,000, also will need to provide substantiated evidence. Also, by the way, will have to provide that substantiated evidence to justify the payment shortfall. And that needs to be agreed and accepted by Four Corners, the subcontractor entity. This was signed by Mr. Alam in the presence of Mr. Lee and Mr. Coy, who you're going to hear from today. In fact, Mr. Lee was the notary on this specific promise to pay and this guarantee agreement. In September of 2018, there was also another email that was sent by Mr. Alam to Mr. Coy, indicating in September that he would confirm that he's going to get his best 1.3 million, worst case 1.1. Mr. Coy will testify that he did not agree to accept less than what had been agreed to by the parties in March, but he took this as evidence that Mr. Alam was going to try to get the subcontractor the money that he had promised and in writing agreed to pay. In addition, in March of 2019, Mr. Alam provides a payment record effectively giving Mr. Coy an overview of all the payments that had been made and agreeing that even the payments that were held back by the owner to pay Four Corners, because at some point Alam and also stopped paying the subcontractor directly and the subcontractor had to get the money directly from the owner, that all of that would be counted. And we don't disagree with that, that would be counted towards the total price that would be paid to Four Corners. Ultimately, Mr. Alam agreed in March of 2019 he'd make another payment of $250,000 to get Four Corners up to $1,047,050.70. So what is the relief we're seeking today, Your Honor? Four Corners simply wants to be made whole. The owner held back payments to satisfy expenses. The testimony and evidence will show that. And when Four Corners could not be paid because of also an Alam's breach, Four Corners were able to recoup in total about $1,050,000, $840.40. And that is the total amount that they were able to recover from the subcontract price by withholding those funds based on an agreement between the GC and the owner. And this is the total amount of offsets and credits that we've calculated and that Mr. Lee and Mr. Coy are prepared to testify about today.
Counsel, this is your 2-minute warning.
Thank you. And the plain and ambiguous language of the written guarantee and agreement signed by Parways Alam says, Your Honor, that he will pay a guarantee of at least 1.3 million and up to USD $1,563,000. The agreement further provides that anything less than $1,496,000 shall be paid unless there's some substantiated evidence to justify the payment shortfall, which the testimony will show there is none. And so what are we asking for, Your Honor? We're asking for a difference between what the contract sum was and what payments were actually made to Four Corners. The payments, as we've totaled, are about $1 million. We're asking for the remaining balance, which is about $445,159.60. We're also asking for attorney's fees, which we've tried to be efficient in this case, Your Honor. $40,000 is what we're asking. This is actually up $10,000 from a few weeks ago because of all the the rush to respond to some of the more recent things that were filed by the other side. And in total, Your Honor, we're asking for relief of $485,000, $159.60. And we ask the court that the court find that there has been a breach of contract. Alternatively, that there has been some unjust enrichment on the part of Parways Alam and also construction. Alternatively, as quantum merit as well. But the focus today, Your Honor, is this breach of contract, which we believe we will carry that burden and the court will need to find in our favor. Thank you.
All right, defendants.
Thank you, Your Honor. To start out, this is a simple case and it is about breach of contract. And in order to determine what the court has to decide today, we look at the operative.
Did you say rich contracts or which contracts?
Breach of contract. This is a case about a breach of contract. Sorry, Your Honor.
Okay.
If we look at the operative pleadings of what the plaintiff has proved, the plaintiff contends that defendants and plaintiffs entered into a valid written agreement in which money was to be exchanged in consideration for consultation, work, goods, services provided in relation to the project, Highland Senior Living Village, which is owned by Mr. Coe. Plaintiff as a party to this agreement is the proper party to sue for breach of this agreement. Now that's Four Corners. And it's very important in this case that we distinguish the damages and the actions of Four Corners from other parties who you will see evidence for that allegedly incurred costs. But regardless, this is the key operative statement in their pleading. Plaintiff performed its obligations under the agreement. That is it. They have not pled partial performance. They have not pled excuse as to why no performance was made. They pled for full performance. Yet Your Honor will hear the sworn deposition testimony of the designated corporate corporate representative of the plaintiff, who admitted under oath that they did not complete full performance. In fact, he says specifically, from 2017 to November 2019, we had spent at least $1 million, and there's more that we need to spend to complete the job. And he goes on to describe that it's his contention that Four Corners was unable to complete the job, allegedly because Four Corners hadn't been paid. But regardless, they are suing for breach of contract and the balance of a contract to which they have the burden to prove full and complete performance. That's, as a matter of law, they have to prove one, a valid contract exists, performance by the plaintiff, breach by the defendant, and damages as a result. They will not be able to show full performance here today. Therefore, they are not entitled to the balance of their contract as a matter of law. They would then be subject to a quantum merit claim, which would be given to them the value of the services that they are able to provide or to evidence that they provided in exchange for the payments that they have admitted that they received. One point of clarification, there was no failure of payment from Allsol to Four Corners. Mr. Coe elected to withhold those monies from payments owed to Allsol rather than have Allsol pay a check to Coe. The entire record of evidence will be devoid of any demands for payment, any invoices for payment, or any other correspondence saying payments had not been made because there was no non-missed payment. The evidence will clearly show that the plaintiff cannot meet its burden of proof here today, and that it is not entitled to the balance of its contract. Now, when we look at what the plaintiff is claiming it incurred as costs, the deposition of Mr. Lee is very instructive, as will be brought out here later today. First and foremost, Mr. Lee confirmed that Four Corners itself has incurred only $390,000 of claimed costs. The other costs that Four Corners claims performance on were not actually performed by Four Corners. They were performed by the owner of the project, Highland Village Senior Living LLC, and another entity not a party to this suit, Highland Senior Living Arlington LLC. Neither of which are parties to this suit, neither of which are entitled to recover damages by and through Four Corners, and Four Corners will be unable to show performance or damages as a result of any breach by the defendant. Lastly, the contract upon which they sue and their otherwise is clearly signed by Mr. Alam, president of Allsol Construction, and notarized in that manner. It is titled Mr. Alam of Allsol Construction. It is stated in the first paragraph, I, Parwaz Alam of Allsol Construction. He has never implicated himself in an individual basis for anything that is at issue in this case. But most importantly, the evidence will show here today that this $1.3 million did not just come out of the sky. It was based on specific performance that was required of Four Corners that Mr. Coe and Mr. Lee will acknowledge from the pay apps of the greater project. And they will be unable to show that they tendered that performance that would entitle them to the recovery of any further monies under either any of the causes of action brought. Under a breach of contract action, since they will be unable to show or evidence full performance, they are not entitled to the balance of their contract as a matter of law. They have not pled excuse. They have not pled substantial performance. They have not pled partial performance. They pled full performance, and they will be unable to do that today because the facts will come out that Allsol was the party who performed some of those items that Four Corners was obligated to perform, which it did not perform, plus by the sworn testimony of Mr. Lee, who already acknowledged that they were not able to do everything, allegedly because they had not been paid. As such, plaintiffs should not recover anything at the conclusion of this trial and the evidence today, and Allsol should be given judgment. Thank you.
Okay, call your first witness.
Your Honor, the plaintiff calls Mr. Gary Lee.
All right, is Mr. Lee on there? Okay.
Good morning, Your Honor.
Please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Good morning, Mr. Lee. Please state your name, full name for the record, please.
Yes. Good morning, Mr. Martinez. My name is Gary Yichu Lee.
And how old are you, Mr. Lee?
I'm 28 years old,
And where is your residence?
in Dallas, Texas.
Now, you're here today on behalf of Four Corners Development Limited Liability Company. Is that correct?
That is correct.
And what is your role at Four Corners?
I'm the corporate representative as well as the CFO of the company,
And what is the CFO?
Chief Financial Officer.
What does the CFO at Four Corners Development, you yourself, do for Four Corners?
Prepare the budget. I'm also involved in contracting with vendors to provide the works and goods and services for this project.
And are you familiar generally with this lawsuit?
Yes.
Do you know who the defendant, Allsall Construction, is?
Yes.
Who is that?
Mr. Pawai's Alam of Allsall Construction, Inc.
I'm sorry, let me rephrase my question. What is Allsall Construction's role in connection with this lawsuit?
Allsall Construction is the contractor for Four Corners Development. So Four Corners is the subcontractor of Allsall Construction, Inc. for this project.
And Allsall Construction is the general contractor on this project?
That's correct.
And you mentioned Mr. Parway's Alam earlier. Who is Parway's Alam now?
He's the president of Allsall Construction, Inc.
And are you generally familiar with the construction project or I guess the Mansfield facility that's being constructed or had been constructed?
Yes, I'm familiar with it.
Now, you said you're here today representing Four Corners, and you mentioned just a moment ago that you had a subcontract with Four Corners. Can you just briefly describe who Four Corners is, what they do?
Yes. So Four Corners is a Texas entity. We provide furnishing, artwork, like low voltage systems to assisted living facilities.
And how is Four Corners related to this specific project?
Four Corners is, we provided what I just mentioned earlier, all those goods and services for this project. But we are a subcontractor of Allsall Construction, Inc., who is the GC for this project.
How long had Four Corners been working on this project? Well, let's start with, when did they start working on the project?
As early as 2016, before the project broke ground, I've already started getting bids for all the products and services that we need to furnish for this project.
You said so were you involved in Four Corners when it first broke ground or when it first began providing these services to the project?
Correct. I mean, before the company was even formed, when we were out getting bids from various contractors, being in this industry for such a long time, I know who to go to get, bids and quotes to provide all these items for an assisted living facility.
Now, you mentioned earlier, generally familiar with this lawsuit. Do you know why Four Corners brought this lawsuit against Allsall?
Yes, because Allsall Construction didn't fulfill the obligation to pay Four Corners the full contract amount.
How are you familiar with that? How do you know that?
We have an agreement signed between Allsall Construction and Four Corners Development for a value of no less than $1.496 million.
Now, were you involved at all in providing or preparing documents that were sent to the general contractor on behalf of Four Corners?
Yes.
And in connection with this case, were you involved in I guess, collecting and providing documents to substantiate your claims in this case?
Yes.
I want to show you what has been previously marked as Exhibit 8, and I believe it was pre-admitted.
At Exhibit 8.
PX8, I should say.
Yeah, it's been pre-admitted.
Let me pull it up. May I share my screen, Your Honor?
You may.
Mr. Lee, this is an email that was dated March 13th, 2017. Do you see that?
Yes.
And it's referenced as PX8, and it looks like it is from you to Mr. Parway's alum over on this project, correct?
That is correct.
What is the email sending, or what was the purpose of sending this email?
It's the signed unconditional lien waiver for the two payments that also construction has paid to Four Corners in 2017.
So is it your testimony today, Mr. Lee, that there were payments that were made by Allsall Construction to Four Corners?
Correct.
And this was a lien waiver that you signed. Do you know why you signed this?
I'm not sure if I signed it. Maybe one of the corporate, yeah, Eric Tan. There we go. He signed it. I just, I notarize it and scan it and send it back to also construction.
I apologize for saying you signed it, but do you generally understand why Four Corners would sign a document like this?
Yes, to to show that we received the payment for the works and services that were provided for this project.
Now, is this the only lien waiver that was provided on this project?
I believe there are more.
And would the lien waivers be sent for the same reason, to receive payment from Allsall?
Yes.
Now, it does say in this lien waiver that this has been received and it's a progress payment in the sum of $467,050.50. And it references the check. And then it says, for all labor, services, equipment, or materials furnished to the property. Do you see that?
Yes.
And it says, to the following extent, material purchase. See that?
Yes.
Did Four Corners, in fact, provide materials and furnishings on this project?
Yes.
And how do you know that?
Well, I was one of the person that goes out to bid for, to get quotes from different vendors. And we have to, there are agreements, there are invoices, emails from vendors to substantiate all this, all the expenses.
Did you keep track of all the payments that you made?
Yes, I did.
And how did you keep track of all those payments?
Bank statements, emails, hard copies of invoices in general.
Did you collect all of these payments, and did you compile them into any document for this court?
Yes, I did.
And do you believe, did you actually produce a document in this case that contained a summary of all the expenses incurred by Four Corners to show the work that they did on this project?
Yes.
And Your Honor, at this point, we'd like to admit Exhibit 35, which was objected to by counsel, which is the summary of all the payments that Mr. Lee had created.
Okay.
Object on the grounds that it's being offered for the truth of the matter asserted. It's hearsay. It's not a business record.
What is the basis of admitting this document?
This is a summary, Your Honor, of all of the expenses incurred by Four Corners in connection with this case. This was created by Mr. Lee, as he just testified, and it purports to be an accurate reflection of all of the payments that were made.
Again, it's being offered for the truth of the matter. Summary evidence is admissible to the extent all the backup documents are attached thereto.
The backup documents were produced, Your Honor.
It doesn't matter. It's what's in it. What's in it evidence.
I believe they're admitted in the evidence as well, Your Honor.
What exhibits are those?
Let me find them, Your Honor.
think we're looking at TRE, Texas Rules of Evidence, 1006.
Since it's not an original business record of the vendor, it can't be admitted for the truth of the matter asserted under hearsay.
Rule 1006 says the proponent may use a summary, chart, or calculation to prove the content of voluminous writings, recordings, or photographs that cannot be conveniently examined in court. The proponent must make the originals or duplicates available for examination or copying or both by other parties at a reasonable time and place, and the court may order the proponent to produce them in court. That's what's required by Rule 1006.
And Your Honor, I can provide that to the court. It looks like it's not on our exhibit list, but we do have a copy of it. And if I can lay the foundation for this exhibit, I can produce it and try to admit it here, Your Honor.
I've never seen it, Your Honor, and I would claim unfair surprise.
No, Your Honor, this has been produced to the other side. Mr. Gasworth personally may not have seen it because Mr. Gasworth has had limited time on this case, apparently. But it has been produced. And in fact, the other side hasn't submitted one discovery request in this case, and it would not be unfair surprise because all of this was produced months ago in connection with this project. And we have the Bates numbers to prove that, Your Honor.
Can I see this exhibit number first so I can know what you're talking about?
Yes, absolutely, Your Honor. Let me pull it up. Just bear with me, Your Honor. Can I just ask for just a couple minutes, Your Honor, to find this?
Would this be a good time for a 5-minute restroom break?
We're actually going to take an early lunch break today, so we're going to probably go another 20 minutes or so and then take our lunch break just because of the nature of my schedule. So
I'll hold out. I'm fine.
Let me try to pull this up, Your Honor. It's just I'm trying to find where it would be. And I believe
I just want to see the exhibit that you're trying to show. I don't need is this the exhibit?
No, it's not. I'm not sharing my screen yet. I'm actually going to pull this up. Hold on.
I have it up if you want me to pull it up.
You have, wait, the exhibit itself, the summary itself, Your Honor?
Yes.
That exhibit? Oh, yeah, I can pull that up, Your Honor. Sorry, I apologize, Your Honor. I thought you were asking for a different document. All right, Your Honor, I am going to share my screen now.
No, that's not it.
I don't know what this is.
That's not the right document.
No, this is the document I was trying to prove up and admit. Are you talking about the backup documents?
Nathaniel, on my screen is your exhibit list.
Oh, let me go back. I apologize. I think I know what happened. Here it is.
Okay. All right, so to prove up under 1006, you would need to show that you produced these documents, I guess, to the other side, which I'll let you, I guess there's some dispute about that. Is that accurate?
Yes, Your Honor. We haven't received the checks, the invoices for these items.
That's not true, Your Honor. It's just not true. We have produced all of these backup documents in this case and in the arbitration, which Mr. Gasworth, here's the backup, Your Honor, that we produced. It's exhibit 206, R206 in the arbitration. See, Your Honor, the COI Bates label at the bottom. I apologize that got in the way. But there is I'll have to let it go away.
And I know what those are. And what my point is that every item on this summary list is not included in those documents.
Okay.
Our position, Your Honor, is that the witness is prepared to testify that this is a summary of the documents that were produced in this case relating to direct payments that were made by Four Corners Development in this case.
Well, actually, the witness already testified that Four Corners didn't make the payments on this exhibit.
That's not true, Your Honor.
Okay. Well, I think the first thing we probably need to figure out before I admit Exhibit 35 is were those all produced for inspection, which is what's required by TRE 1006. So I think at lunch, I'm going to give you guys an opportunity to go over that together, and you can tell me what on this list wasn't actually produced for inspection.
Nathan, can you identify the Bates range for the entirety of what you're relying on?
8903 through 8952. And I might add, Your Honor, Mr. Gasworth did not object to the admission of this exhibit until today, and has not taken an opportunity to confer with me about any of the exhibits that I admitted. All of these exhibits were on our exhibit list a month ago when we met the deadline to admit these exhibits.
Your Honor,
There was no
my
objection
job
raised.
isn't to.
Your Honor, we filed our objections to their exhibit list on the record. We asked and we had actual objections made on the record that were filed with this court.
Can I ask a question? Because I don't know the answer in this particular case. Did you have a scheduling order that detailed how that was supposed to be handled in this particular case?
It was a standard scheduling order for when exhibits were to be, I guess, admitted or offered for admission. And I believe the scheduling order indicates that we were to confer about them in advance of trial to see what we could agree to. I'd have to go back and look at the specific language, but no, this is the first time Mr. Gasworth has objected to the admission of this exhibit. In fact, he asked Mr. Lee about this exhibit extensively during his deposition.
I did, and I will be asking about it, but it still doesn't matter if it's hearsay. It's being offered for the truth of the matter asserted.
Okay, that's just not a proper objection. If your only objection is hearsay, I'm overruling that objection.
Well, my other objection is on the grounds that it's a summary exhibit without the proper backup, and I'll take you up on your offer to confer on the 8903 to 8952 to determine which one of these items does not have any backup to it.
All right. And was there a deadline in the scheduling order? I guess that's the other question I have to object to exhibits.
That I don't have the answer for you right now, Your Honor. I'd have to pull up the scheduling order.
I mean, if there was a deadline for that, then we would need to, that would also affect my ruling. So that would be something useful to know that you can look up during lunch.
Understood, Your Honor. I can continue with the examination, though, in the absence of that specific document.
Okay, go ahead.
Thank you, Your Honor.
I'll allow it to be used as a demonstrative aid at this time.
That works as well, Your Honor.
All right, let's proceed.
Okay. I'm putting in front of you, Mr. Lee, a demonstrative for the purposes of our conversation today. I understand that you had been asked by counsel during your deposition regarding this specific document. Do you remember that?
Yes.
Now, what does this document purport to be in terms of maybe, let's say, not evidence at this point, but a demonstrative for this court?
Right. This is a summary of all the expenses that Four Corners incurred when Pawai's alum failed to pay Four Corners the contracted amount. Four Corners had to ask help from our other entity, which is HVSL, Highlands Village Senior Living, as well as Highlands Senior Living Arlington LLC, to pay, to help keep providing all the furnitures and computer equipment, all the services to complete this project.
Now, I want to help the court understand some of the parts of this document. Okay. At the top of page 1, you'll see the words Four Corners Development LLC. Do you see that?
Yes.
Is it, and what is this number, the 390,809.42? What does that represent?
These are the direct costs that has incurred for this project from Four Corners Development.
And each of those amounts that you arrive to getting this 390,809 number, this is all based on the amounts just above it in that same column, correct?
That's correct.
And then there's a vendor name next to this. Do you see that?
Yes.
And there's also a note that indicates what this payment was for. Do you see that?
Correct.
Is it your testimony that Four Corners Development LLC came out of pocket at least $390,000 on this case?
Yes.
Objection form.
In terms of the actual payment method, how were these payments made?
By checks, and then so I showed the check number and the corresponding bank account numbers.
And Mr. Lee, how do you know that a check, for example, was written in March of 2017 by Four Corners Development for telephone internet wiring? How do you know that?
In general, I wrote those checks and make the payment to the vendors. So I would have the check images, the bank statements to substantiate this summary.
So in terms of each of these payments that's listed in this demonstrative before the court, is it do you have personal knowledge as to each and every one of these payments that was made?
Yes, I would say in general, yes, I have knowledge on all the line items.
And why would you have that knowledge and not someone else?
I'm the one that mainly worked on all these line items.
So before we go further in this document, I want to understand something about the nature of the agreement. You're familiar with the agreement between Parway or between Allsaw Construction and Four Corners Development, correct?
Correct.
And what was that agreement, just in your own words, as you understood it?
The agreement between Four Corners Development and Allsaw Construction Inc. Four Corners is a subcontractor for Allsaw Construction, and our role is to provide furnishings and low voltage cabling, etc., to this project. And ASAL promises to pay Four Corners no less than $1.496 million for this project.
Did Allsaw Construction actually pay all of that money?
No.
How much money did Allsaw pay directly?
Allsaw paid Four Corners approximately $498,000.
But today, as I understand it, you're saying that about $1 million is being credited for that agreement. Is that right?
Correct. The owner of the project had to, also authorize the owner of the project to withhold some funds in order to pay for all these line items or furnishing items.
In order to receive, you said $1,496,000. Was it your understanding that you had that if you had only incurred $400,000, that you would only get $400,000?
No, that was
Why
not
is that?
That was not the agreement. The agreement has always been $1.496 million.
Now, let's go on some further in this demonstrative. There's also other companies listed on here. It looks like they're expenses from other companies. Do you see this expense from Highlands Village Senior Living LLC?
Yes.
Why is this something you're counting as evidence of the furnishings that you provided on this project from Four Corners?
Yes. So from what I said before, we have started, working on this project, getting quotes from various vendors since 2016, before the company was even formed. So at that time, we, like for instance, the first vendor, Tala Rajpanta, he has extensive knowledge in assisted living facilities and specifically, regarding the miscellaneous items like low voltage cabling, computer systems, camera systems, the life safety system. So we had hired him, to help as a project manager to help with all this furnishing items. So, but at the time, the company wasn't formed, so we had to pay him out from another entity. But then after the company was formed, we had received some payments. Then we were able to pay Raj, to reimburse for Raj.
Why is the money, though, coming out of Highlands Village Senior Living for furnishings or specialty items on this project that Four Corners was supposed to handle? Why didn't Four Corners pay these?
Yeah, like I say, Four Corners didn't have the funds at that time, and then we had to, in 2017, we had to pay all the different vendors for all the items, and we just didn't receive enough funds from also construction, but we had to retain Raj to supervise the project and make sure everything is going correctly.
So effectively, Highlands Village Senior Living LLC had to cover Four Corners.
That's correct.
And is that the same with the other entity as well, Highlands Senior Living Arlington LLC?
Correct.
And so all of these expenses in this demonstrative add up to what amount?
Approximately $1.04 million.
Now, you were present today during the opening statement of Mr. Gasworth, weren't you?
Yes.
Mr. Gasworth contends in his opening statement that you didn't fully perform your end of the bargain in connection with this case. Do you agree or disagree with that statement?
I disagree. We have limited funds because Osal Construction didn't pay us. And we have other costs that were incurring due to Osal Construction's delay in the project. For instance, we had to pay storage fee to store our furnitures because Osal Construction kept delaying the project and we couldn't move our furnitures in. So there were extra costs that were incurring at the time. There are a lot of things that we still have to provide for this project that we haven't able to fulfill because we weren't paid by Osal Construction.
So just because there are other things that you have to fulfill, does that mean you didn't perform?
No, that doesn't mean I didn't perform. We have performed and still performing.
And you said earlier you're familiar with the agreement between Four Corners and the general contractor, right?
Correct.
I want to show you another exhibit. This has been pre-admitted. This is exhibit 19. Okay, Mr. Ali, do you see this email? It's PX19, and it's an email from you to Mr. Tan and Mr. Coy. Do you see that?
Yes.
And it's dated March 19th, 2018.
Correct.
It says here, per meeting with Parways today, Allsall Construction has funded the following to Four Corners development to date. Do you see that?
Yes.
And is that an accurate reflection of how much Four Corners had paid directly, or how much Allsall had paid to Four Corners to that date?
That's correct.
And then it says Parways plans to release the following on the next draws. Do you see that?
Yes.
What was your understanding of how they would be released? It says released on the next draws. Was that going to be a payment directly from Allsall, or was that going to be something the owner would pay?
So the next draw, meaning the next time Allsall Construction sends in a pay application to the owner's lender, and the lender pays the owner then pays Allsall Construction, and in turn Allsall Construction would pay Four Corners $185,000, and then a subsequent draw be $125,000, for a total of $310,000 for the next two draws.
Okay, sorry to interrupt. So let's get to the March 19th, 2018 agreement. This says, I, Parways Alam of Allsall Construction, promise to pay a guaranteed sum of $1,300,000 up to $1,563,000 to Four Corners Development. Were you present when this particular document was signed by Mr. Alam?
Yes.
And were you involved in preparing this document for Mr. Alam to sign?
Yes.
Where do you know to the extent to which you've been paid, or Four Corners has been paid under this agreement?
I'm sorry, can you repeat that question?
How much has Four Corners been paid under this agreement?
$498,000.
But well, you say directly from also, but has there been any payments from the owner towards
Yes.
this as well? How much is that total?
Approximately $552,000 from the owner side. So in total, about $1.04 million.
So have you been paid $1,496,000?
No.
And it says here in this paragraph, for any amount that is less than US $1,496,000, also will need to provide substantiated evidence as to justify the payment shortfall. Do you see that?
Yes.
And it says, which needs to be agreed and accepted by Four Corners.
Yes.
Did you ever agree to accept less than $1,496,000?
Never.
Is there a document that you signed as Four Corners Development that says that your Four Corners Development is going to agree to accept less than $1,496,000?
No.
Has there been any documentation provided by Allsol for substantiated evidence to justify not paying you the full amount under this contract?
No.
If the judge determines that there is an enforceable agreement in this case, that is that you're owed there was an agreement to pay $1,496,000. What is left to be paid approximately?
$445,000 approximately, and I'm also seeking attorney's fees, approximately $40,000.
And did you in fact retain an attorney to pursue this case?
Yes.
And who is that attorney?
You.
And how much approximately have you had to pay an attorney to handle pursuing this case?
For this case, approximately $40,000.
So in total, how much are you asking the court to award?
In total, $485,000.
Mr. Lee, to the extent that you were involved in providing these services, now I understand you were present during the deposition of Mr. Alam, correct?
Correct.
Was there anything that you took issue with during that deposition as it relates to this agreement that you'd like to tell the court about?
Objection. Assumes facts not in evidence. There's been no testimony from Mr. Alam for Mr. Lee to take issue with at this time. Your Honor, you're on mute. I apologize.
Overruled.
Go ahead, Mr. Lee.
Right. So in general, Mr. Alam made a lot of false statements during his deposition. Specifically, if I remember correctly, he mentioned something about it's not $1.3 million. It's another figure, which is a total lie. I mean, that's my takeaway. This is a lot of false statements.
Mr. Lee, do you believe what you're asking for is fair in connection with this case?
Yes.
All right, I pass the witness, Your Honor.
Do you want to get started, or you want to go ahead and take a lunch break, Mr. Gasworth?
Yeah, I prefer to take a lunch break so I could just go forward.
Okay, so why don't we take a lunch break? I want you guys to confer about that exhibit, about what has been produced and what hasn't been produced. I don't want to deal with that on the record. I mean, I'll deal with it on the record after you've conferred and figure out what the scope of the issue is, if any, on this. Also, have you guys prepared findings of fact, conclusions of law for me yet?
Yes, Your Honor. Plaintiffs submitted their findings of fact and conclusions of law, I believe, last month in accordance with the court's deadline.
Okay. Mr. Gasworth?
No, I did not, Your Honor.
Okay. Okay, well then, guys, do you want me to keep this Zoom up while we go to lunch, or do you want to?
We can log back in, sir.
Oh, yeah, either way, Your Honor, whatever your preference is.
Well, it's just you guys are going to need to confer. Would it be easier to keep this Zoom, or do you want to go to a different?
Brad, I defer to you.
I'll call you, Nathaniel.
Sounds good.
All right, why don't we reconvene? So that you have quite a bit of work to do, so we'll reconvene at 12:45.
Thank you,
Thank you,
Your
Your
Honor.
Honor.
Yes.